Accordingly, the material placed on record and examined in its entirety establishes that Umar Khalid and Sharjeel Imam stand on a qualitatively different footing from the remaining accused, both in prosecution narrative and in evidentiary basis relied upon. This structural distinction cannot be ignored and must inform any judicial determination relating to culpability, parity, or the applicability of penal provisions requiring a heightened threshold of intent and participation. Before we proceed to individually analyze each of the role attributed to each of the accused, we would like to reiterate the obvious but very important distinction while considering the bail applications in general and under special statutes like UAPA. The record discloses that all the appellants do not stand on equal footing as regards culpability. The allegations against principal accused indicate a central and directive role in conceptualizing, planning, and coordinating the alleged terrorist act, whereas the material against certain co-accused reflects conduct of a subsidiary or a facilitative nature. Accordingly, the material placed on record when examined in its entirety establishes that Umar Khalid and Sharjeel Imam stand on a qualitatively different footing from the remaining accused, both in prosecution narrative and in evidentiary basis relied upon. This structural distinction cannot be ignored and must inform any judicial determination relating to culpability, parity, or the applicability of penal provisions requiring a heightened threshold of intent and participation. As required at this stage, discloses a prima facie attribution of a central and formative role by the appellants in appeals arising out of SLP criminal number 14165 of 2025 and SLP 14030 of 2025, Umar Khalid and Sharjeel Imam in the alleged conspiracy. The material suggests involvement at the level of planning, mobilization, and strategic direction extending beyond episodic or localized acts. The statutory threshold under 43D5 of UAPA therefore stands attracted for these appellants. While the period of incarceration undergone by these appellants is substantial and has been duly considered, the court is not persuaded that on the present record, continued detention has crossed the threshold of constitutional impermissibility so as to override the statutory embargo. The complexity of the prosecution, the nature of evidence relied upon, and the stage of the proceedings do not justify their enlargement on bail at this juncture, as noticed in detail in the discussion made here in above. Hence, the appeals arising out of SLP criminal 14165 of 2025 and SLP criminal number 14030 of 2025 stands rejected. We reiterate that courts are under constitutional obligation to ensure that criminal proceedings, particularly those involving prolonged pre-trial incarceration, should progress with utmost expedition and the accused are not left to languish in jail. At the same time, the court is mindful that pre-trial detention, even when justified by the statute, cannot be permitted to continue without regard to the progress of the trial. The restraint on liberty contemplated by law must proceed alongside a meaningful advancement of the prosecution. In the present case, having regard to the reliance placed upon the protected witnesses, this court considers it appropriate to provide a defined point for consideration of their prayer for grant of bail. We are of the opinion that on completion of the examination of the protected witnesses relied upon by the prosecution or upon the expiry of the period of 1 year from the date of this order, whichever is earlier, these two appellants would be at liberty to renew their prayer for grant of bail before the jurisdictional court. In the event of such prayer being made, it shall be considered on its own merits, having regard to the stage then reached in the proceedings before the trial court and without being influenced by the impugned orders or the present order. This course gives effect to the statutory discipline embodied in section 43D5 of the UAPA while ensuring that the constitutional guarantee under Article 21 operates as a continuing check against continued incarceration without there being any substantial progress of the trial. The appeals arising out of SLP 13988 of 2025, Gulfisha Fatima, SLP criminal 14132 of 2025, Miran Haider, SLP number 14859 of 2025, Shifa ur Rahman, SLP number 15335 of 2025, Mohammad Salim Khan, and SLP criminal 17055 of 2025, Shadab Ahmad are allowed, as the court is of the view that having regard to the role attributed, the nature of the material relied upon, and the present stage of the proceedings, continued incarceration is not shown to be indispensable to the conduct of a fair trial, provided strict safeguards are imposed. The grant of bail in their favor does not reflect any dilution of seriousness of the allegation, nor does it amount to finding on guilt. It represents a calibrated exercise of constitutional discretion, structured to preserve both liberty of the individual and security of the nation. The appellants granted bail shall be released subject to the following conditions which are imposed, not as a matter of form, but as a substantive safeguards in the interest of national security, public order, and integrity of the trial process. We have imposed about 12 conditions, and we have said in case of breach of any of the aforestated conditions imposed, or in the event of appellants having misused the liberty granted, it shall be open to the trial court to cancel the bail, which would be necessarily after affording opportunity of hearing to the appellants. Before we conclude, it bears reiteration that a principle lies at the heart of constitutional adjudication in matters of this nature. The Constitution guarantees personal liberty, but it does not conceive liberty as an isolated or absolute entitlement detached from the security of the society in which it operates. The sovereignty, integrity, and security of the nation, as well as the preservation of public order, are not abstract concerns, rather, they are constitutional values which Parliament is entitled to protect through law. Where a special statutory framework has been enacted to address offences perceived to strike at these foundations, courts are duty bound to give effect to that framework, subject always to constitutional discipline. In the application of such law, the court does not proceed on identity, ideology, belief, or association. It proceeds on role, material, and the statutory threshold governing the exercise of jurisdiction. Criminal law does not mandate identical outcomes merely because allegations arise from the same transaction. Those alleged to have conceived, directed, or steered unlawful activity or terrorist activity stand on a different legal footing from those who alleged involvement is confined to facilitation or participation at a different level. To disregard such distinction would itself result in arbitrariness. The present decision reflects this constitutional method. It neither endorses the prosecution case nor prejudges the guilt of any accused. It applies the law as it stands, recognizing that individual liberty must be protected, but that it must also withstand the legitimate demands of national security and collective safety. This balance is not a matter of preference, rather it is a matter of constitutional duty. Before parting, it is necessary to reiterate the limited nature of the present determination. The court has not examined the merits of the prosecution case beyond the confines mandated at the stage of consideration of an application seeking bail, or has it expressed any opinion on the ultimate culpability of any accused. All the observations are confined to the material present on record to the statutory and constitutional standards governing pre-trial liberty under a special enactment. Having regard to the nature of the prosecution and the period of incarceration already undergone, it is considered appropriate to direct the trial court that the trial court shall proceed with the matter with due expedition and shall endeavor to ensure that examination of witnesses, particularly the protected witnesses relied upon by the prosecution, is taken up and carried forward without any delay. The prosecution shall take all necessary steps to secure the presence of its witnesses on the dates, and parties shall refrain from seeking adjournments except for reasons which are unavoidable. The trial court shall be at liberty to regulate the proceedings in accordance with law so as to ensure that the trial is not unnecessarily prolonged, while at the same time safeguarding the rights of all parties. It is clarified that these directions are issued in furtherance of the obligation to ensure fair and timely trial and shall not be construed either as an expression on the merits of the prosecution case or as a constraint on the discretion of the trial court in the conduct of the proceedings.